supplementary cause list, item number 1.
Please, Your Lordship. Well, this is an application for bail in connection with an NTPS matter. Yeah, my lord, 3 people were arrested. Now, my lord, the statement has been given by one of the co-accused that I am not involved in the case. Well, nonetheless, my lord, today I am here only praying for interim bail on medical grounds. Right from the time of my arrest, my lord, I have been hospitalized time and again. Now, on the last occasion, my bail was rejected because an opinion was given by the doctor that I am fit. But unfortunately, today, just yesterday again, I have been hospitalized. Well, I suffer from a very serious.
What is the nature of your ailment?
Well, it is it's called lumbar. Well, he's having this back pain, which may lead to paralysis also if not given proper treatment.
So you think the treatment at the civil hospital
My lord, had it been the case, my lord,
hospital are inadequate?
my lord, had it been the case, then my lord, I would not have been taken to hospital time and again. If I show lots of the medical reports, I have been in and out of the hospital on 4 to 5 occasions.
Was he ever referred to Negrims?
I don't think so, my lord. It was always long for civil
Mr.
hospital.
Sunkar?
My lord, we will require some.
He was hospitalized at Nongpo Civil Hospital?
Nongpo, my lord.
No,
Not even Shillong.
Again, he's hospitalized there.
Then he could have been referred to Shillong or Negrims for that matter.
My lord, the problem with this particular illness is that, my lord, if it's not given treatment on time, then, my lord, the entire lower portion will be paralyzed. So that is, it's a very serious. My lord, in fact, Lordship will see. Lordship will call for records. My lord, Lordship will see that what has happened here is that 3 people were there in the commercial vehicle. One person here is given a statement that he was asked by somebody to transport drugs. He has confessed to the crime, but he does not take my name. He says that these 2 people were there with me. They are not involved. But if, my lord, since it is commercial quantities, so of course, my lord, I do understand my limitations. But, my lord, at least
It has been filed.
charge sheet has already been filed.
it is a commercial quantity, and plus he was taken to the Nongpo.
What is the stage of the case?
I think charge sheet has recently been filed, my lord.
We need,
My lord, at least a medical report may be called for because as of today also I am hospitalized again.
Heard counsel for the petitioner who has submitted that the limited prayer of the petitioner herein is for grant of interim bail as regard the accused. You're the accused.
I'm the accused.
Okay. Hajakartu of the applicant ma. Of the applicant hearing. Yeah, it's for grant of interim bail so as to enable him to be referred for specialized treatment in a private institution of his choice, given the fact that he is suffering. What exactly is
My lord, it's lumbar spasm radiculopathy.
where do you find that?
My lord,
I can't even pronounce it.
but I'll read it out, but I'll spell it. LUMBAR, then spasm, SPASM, and RADICULOPATHY. It's quite a serious disease, my lord, because it ultimately leads to paralysis if proper treatment is not given.
Not for us to say. I will not know it.
But I've just done a little bit of research, my lord. That's why, otherwise I would also not know.
Which is serious in nature, and as such, liberty of this court is sought for to allow the applicant to go on interim bail for treatment. For treatment. It is also the submission of the learned counsel that the applicant has been given or rather referred for treatment by the jail authorities and has been and has been admitted at the Nongpo Civil Hospital and was also discharged. But however, on being discharged, he was again referred to the same hospital on 5th, that is yesterday. Next, Mr. Enscon, Leonard Counsel, Leonard J, appearing for the state respondent, has however made a prayer for the latest medical status of the applicant to be produced before this court so as to enable this court to pass necessary orders. This court, on consideration of the submission made, would deem it fit and proper, firstly, for a medical report to be produced so as to know the latest status of the applicant, and also as to the opinion of the doctor, if any specialized treatment is required or not. In the meantime, it is incumbent upon the jail authorities to ensure that the best possible treatment is given to the applicant, accused. He may even be referred to government hospital at Shiloh, or even Negrams for that matter. On preamble, the prosecution is directed to furnish the said report on the next date fix. List this matter on 11th.
Item number 2.
Worship, there's also a bail application with connection with NDPS case, my lord. Only case here is, my lord, nothing was recovered from my possession, my lord. Nothing was recovered from my possession, my lord. The entire case, my lord, I was arrested on the basis of an FIR, my lord, 19/6/2023, my lord.
Yes.
After my arrest, my lord, I was sent to 3 days police custody. Thereafter, my lord, on 20th, reproduced on 22nd, and after that, 14 days police custody. Bill application was moved before the learned special judge, Clariat, my lord. That was rejected on 2nd of August, my lord. My lord, will kindly come to the FIR, my lord, at page 7. On the basis of this FIR, my lord, I was arrested, my lord. Even in the FIR, my lord, I was not named, my lord. On the basis of this, my lord, the case has been charge sheeted, and your lordship will, if your lordship come to the charge sheet at page 11, annexure 3, my lord, even the IO has categorically admitted that nothing has been seized from my possession, my lord. My lord, page 21, my lord. We'll see the column commencement of search operation, procedure, recovery of suspected NDPS material in presence of independent witness. My lord. Page 21, my lord.
Yes.
I'll just read it out. My lord. On arrival of two independent witnesses at Cleared Police Station, self was authorized by Police GO Sri B so-and-so yes, to conduct body and vehicle search of the detained vehicles and the detained person, and accordingly the search operation started at Cleared PS campus in presence of the independent witnesses. So. It is to be noted that no suspected contrabands recovered from the body of so-and-so, 6 others, and no suspected contraband was recovered from the vehicle of Sri Karnajit Sarkar bearing registration number so-and-so. My lord, I was travelling in this particular vehicle, my lord, bearing registration number TL01 BW231, my lord. So, my lord, nothing was recovered from my possession, from me also, and from the vehicle in which I was travelled, my lord. So, my lord, I would pray that since nothing has been recovered from my possession, my lord, so I am praying for bail on that ground.
See, as far as the vehicle is concerned, this vehicle belongs to you.
No, my lord, this is a different person altogether. I was just travelling in it, my lord.
Is it a commercial vehicle?
No, private vehicle, my lord.
Private vehicle.
Private vehicle, my lord. I was only in the open of the vehicle, my lord. The accused person, my lord. So I'm praying bail only on that ground, my lord. The accused has been behind bars for more than 2.5 months. The case has been charge sheeted. They will face the trial, my lord. All investigation has been completed, my lord.
What is the
Quantity,
offence alleged against you, section?
well, section 20B, 2C, 27A, and 29, my lord.
Commercial quantity.
Commercial quantity, my lord. That has been recovered from other vehicle, my lord, not from the vehicle in which I was travelling, my lord. There are 2 vehicles in this case, my
Two
lord.
vehicles.
My lord.
Yes, miss.
Lordship, I'll have to seek instructions, my lord, because I don't have any instructions as of now.
So we'll you seek instruction.
Lordship.
If possible, get the necessary records. Though most of the materials are here, the charge sheet and whatever that is required to be.
I'll get an extract copy, Lordship.
Get an extra.
Lordship.
How soon?
A week's time, my lord. Maybe on Thursday.
Right.
Lordship.
Mr. Kriam, letter counsel for the petitioner, who has submitted that the
Petitioner is the brother of the accused person, my lord.
submitted that the brother of the petitioner is an accused in connection with what is the case, NDPS case number?
Criminal NDPS case number 25 for 2023, my lord.
Criminal NDPS case number 25
of 2023.
under section I2. No? The learned counsel for the petitioner has submitted that this application is filed for grant of bail as regard the said accused person on the ground that he is not at all involved with the alleged offence, and that there is no material or evidence which can link him to the alleged offence. The relevant portion of the charge sheet, which has been annexed with this petition, has been referred to by the learned counsel for the petitioner, which appears at page 21 of this petition, in the second last paragraph, in which it is clearly, in which the IO has clearly indicated that no suspected contraband was recovered from the body of the accused person herein.
Nor from the vehicle in which he was traveling.
Nor from the vehicle in which he was traveling. It is on this ground that the prayer for grant of bail is made. Excuse me. Ms. Angela, Senior GA has submitted that instruction may be allowed to be sought for and to sought for, and as such it is prayed that this matter may be taken up on the next date fix. On consideration of the submission made, this court will allow the prosecution to produce whatever relevant material is available in opposition to the prayer made by the petitioner herein. It may be noted that Section 37 of the NDPS Act is involved herein, for which the on permit, this is matter on
14th, my lord. Lordship, if you kindly just mention an extract copy of the
you see the instruction and bring whatever is required.
Lordship.
Instruction, including extract copy of the CD or any relevant materials.
Much obliged, Lordship. Much obliged, Lordship.
2, 3, 4, 5 is
Same.
connected matter.
Same prayer from us, Lordship.
Same order.
Acknowledgement.
Much obliged, Lordship.
Really costless, item number 1.
Your Lordship, I appear for respondent number 12.
Lordship, I seek your commission for today.
I was looking at this file, it's bulky. There's so much wear and tear. Means this matter has been off and on this board for
quite long,
some
my
time.
lord. The matter has been adjourned for quite long.
When?
After 2 weeks, your Lordship.
Prayer is made on behalf of the petitioners on the ground that the senior conducting counsel is indisposed. On the same not be objected to by the respondent, matter is adjourned. This is same after 2 weeks.
Any grudge?
Deeply obliged, Your Lordship.
Item number 2.
Please, Your Lordship. Lordship, this matters for admission hearing on the question of maintainability relating to locus. If Lordship is inclined, if everyone is ready, we can take up the matter.
I'm reading. How is the union involved here?
You're not on this.
Beg your pardon, Milord. How is the union involved here?
The union is not a party.
Yeah. For the union.
Union is not party in this case.
Sorry. Dr. Mozika is appearing on whose behalf?
Union is not a party.
No.
Or maybe.
You see,
There's no union, Lordship.
No union. Page 18. Other parties are protected.
Mr. Sangwa is for respondent 3.
I'm for the private respondent number 3, Lordship. Yes.
So,
Here
one,
no union, Lordship.
1 and 2 is.
I'm for 1 and 2.
1 and 2. We have only 3 respondents.
3 respondents.
So,
You're not. She's not there.
how come you are?
No, this is not. This is a different case. No, this is different case. Different case. No. Not this one. Number is different.
I've never come across an intervening situation as this.
When one appears in too many matters, this may happen.
So, yes, Mr.
Lordship.
One preliminary objection, Milord. Though Lokayukta has been made party in this case, but Lokayukta is a quasi-judicial authority. And quasi-judicial authority like labor tribunal, they are not the authority which will defend their own order. And therefore, because I have the compilation of judgment, Milord. Recently in Madhya Pradesh, the Honorable Chief Justice was hearing the division bench where the decision of Lokayukta was not implemented by state government. And then Lokayukta filed the writ petition. Then the division bench of the Madhya Pradesh High Court held that Lokayukta is a quasi-judicial body and it has no right to contest or support or deny because Lokayukta is a judge. So and therefore judge will not come and defend its order. The complainant will come and defend the order. Therefore, now what we have seen that in most of the cases we are making Lokayukta party to the case.
Why have you done it?
That should not have been done. There's an error on our part, my lord. This is an error on our part. Because Lokayukta is a judge who is deciding the list between two complainant and the private parties.
So if I can respond to that, my lord. Number one, Lordship has noticed I've been made a party by the petitioner himself. And secondly, my lord, what I'm raising today is an issue of locus of the petitioner. Petitioner in response is... No, if I can finish, my lord. Lordship, now they are raising the issue of my locus to address this honorable court. Lordship will decide this issue. Lordship will hear me. And when deciding the issue of locus, which I have raised, Lordship in the same order will also decide.
Locus has already been raised by the...
Now, it is for the petitioner. I mean, that is well said. No, we know it.
That was a mistake which I admit.
To whom to make parties in the proceedings.
Absolutely.
If you are deemed not to be involved, why would you poke your nose? If you say no, I'm not. I don't want you to be there. So you go out.
Lordship, because here...
I am the dominant status of the matter.
Dominant status is the petitioner, definitely. So it was the choice of the petitioner to make or not make. I humbly submit that they have correctly made me a party for the reason that this particular order is being passed not by a court in the usual sense, my lord. A court in the usual sense would be a court constituted under CPC, etc. This is a court, I will not even use the word court, my lord. This is a public authority that has been set up under a special act, my lord. So a special act has given certain powers to this public authority. This public authority has exercised those powers, rightly, wrongly. they're saying wrongly, and therefore they have come before this honorable court. So in other words, what is happening here through this writ petition is state actions of a public authority is being challenged. So when actions of a particular public authority is challenged, naturally, my lord, that public authority is required to be made a party, which they have done. So that's why I had said that they have correctly made the Lokayukta a party. Having made me a party, having let the matter linger for about 2 years, after I have raised the issue of locus of the petition himself.
I have to, in any case, satisfy the issue of locus. That is the plaintiff. That is a private.
That's true.
So what I was.
But the question is, my lord, the question is whether Lokayukta.
No, let us hear.
So what I was requesting humbly is that Lordship may hear me on the issue of locus which I have raised. During the course of my submissions, I will attempt to meet the issue of locus which they have also raised. And when Lordship is adjudicating this matter, the issue of maintainability, Lordship will also obviously have to touch upon whether I can or I have a right to be heard by this honorable court. If Lordship decides that I have no right to be heard, then the issue of locus which I have raised has no meaning.
Mr. General, what would I may be wrong for all we know.
Yes,
but it is up to the petitioner whom to make party.
True,
if he wishes to strike you off the rolls,
let him file a petition to strike me off.
So, you see, if you feel that you are a necessary party,
yes,
then you can come by way of an intervening application.
So, very well. So, if the petitioner is taking the stand instead of meeting my issue of locus, if the petitioner is taking
raising the issue of locus, that you have no locus to stand.
If the petitioner is taking the stand that I have no locus to address this honorable court in spite of being made a party, very well, let them file a petition to amend the writ petition.
I will do that.
I will, as on date I am a party, I will have a chance to respond to that petition.
I'll move the miscellaneous.
Yes, you can do that.
Yes, ma'am.
You can do that.
I'll move the miscellaneous.
This case, Lordship, this number of cases whereby the petitioners and others, they have make a party to the Lokayukta, and a lot of judgment have been decided, even reached the Supreme Court on that. Recently also, they make a party to the even to the Lokayukta. This is the first time that AG is raising this issue.
So, you see, if that is the case, we will hear
the issue.
The court will hear on the issue. If at all the Lokayukta is a proper necessary party, then he will be heard.
Absolutely.
Or it will be
If they say that there is a defect, let him withdraw and file a phrase, Lordship.
Why should
they can?
He has made a prayer to file an application.
Application to amend the memo party, deleting the Lokayukta from area of parties.
So you'll be also given a chance to
reply to it.
Lordship, one thing is that this case has been dragging since from 2000. This is unnecessary because the main condition.
Let us not go into that, because that is always the usual refrain. That this matter has been dragging because of this, but
main thing is that
it is the system as such. What can we do?
Lordship, but one should be appreciated that actually I am the main person who filed a complaint. Now I filed a complaint. There are 46 projects which has been given to the one particular MTC and the contractor.
1100 contractors are there. 1100 contractors.
Lordship, let me just. And none of these projects which they have allotted have not been compliant. And then we filed a complaint. The preliminary inquiry has been reported. It found prima facie that none of the project has been completed. Now my learned friend is issuing the issue because the maintainability, because
that would be touching on the merits of the
Lordship, he is coming and filing on behalf of the.
Yeah, that is wrong, because if I'm aggrieved with the illegal order passed, then I am saying you want to proceed against the contractors, you please proceed. But proceed as per law. Proceed whether you have the power to do, you do it in proper way, proper manner. State will never oppose, state will support you. But you pass the order saying that register FIR against 1500.
Lordship, these are on the
and
merits.
You do not have power to register. So my friend has started on merit. That is why I am going on merit.
These are on the bill. It's not very necessary at the moment.
That will. I will move the appropriate application.
It may be a peak situation.
Actually, they are nobody. He has correctly stated that The issue
I'm
is
straight.
between me and the contractor and the MDC.
Lordship, in this
He
matter,
is nowhere.
Lordship, in
He
this
is the
matter,
political.
Fine, fine. Yes, so we'll hear you.
in this matter, my lord, nobody appears to be anybody. They are saying I'm nobody. I'm saying he's
Because
nobody.
I am the
he's
main
saying-
complainant, I filed not against the police department. I filed against those particular who have not implemented the project. I filed against the contractor, against the MDC for non-implementation of the project. They are nobody.
See, Mr. Sangma, we are
I
here.
am coming and defending.
So, fine, we'll hear you.
That is what my learned friend is defending. He has no locus. Now he is changing his verse. Since from 2018, he never raised this issue.
To 21.
Today is the first time that
21
he raised.
is a,
Today is the first time he said that Lokaita has nobody to defend the case. Since for 2-3 years, he never raised this issue. With due respect to my learned senior AG.
Fine.
Today is the
So
first
we'll-
time that he has
So
said
we'll
this
hear
issue.
the matter,
yes, so I will move miscellaneous application.
but we'll do it as soon as possible.
Yes,
naturally.
File it by Monday.
Monday will Monday is some vacation holidays. There Tuesday by within a week will within a week.
Within a week.
Copy should be given to us.
Yes, we will have to give you a copy.
Yes.
Otherwise, they don't
Without-
even make me a party.
No, we have meant now.
No,
You are
see the
party
original,
now.
original 18.
In fact,
Yes, we
in
who
fact,
file application.
my friend is right.
Yeah,
His-
initially there was
they
some
don't even make me a party.
there was some mistake
come
in the
Not a
drafting.
mistake.
the order
Inadvertent
passed in his favor
error.
was
I will
stayed,
say inadvertent error.
without him being made a party.
Okay.
That was little incorrect.
It was later I inquired, they make me a party.
Fine. Mr. AG, A. Kumar, Leonard AG, has submitted that the petitioner may be allowed, the state petitioner may be allowed to file
Miscellaneous.
an application for amendment of this petition in as much as the name of the respondent number 1 and 2 are required to be struck off from this procedure. The learned counsel for the respondent 1, 2 and 3 respectively has no objection to the prayer made, but has however submitted that they may be allowed to respond to such application if so filed. Accordingly, the state petitioner is allowed to file the said petition with advance copy to the respondent herein, and if response is to be filed, the same may be filed within the next date fix.
That is
You understand?
That is subject
You
to
file
them giving
advance, give advance copy
Yes, my lord.
a copy well in advance.
well in advance.
Within 1 week
So
and
I'll
then
go,
1 week time.
then we'll fix this matter. Yes. Fix this matter after 2 weeks. This is matter after 2 weeks.
Obliged.
So you file a response to that, then the matter will be heard.
So then
Otherwise,
matter will be heard.
Then you go on to the next date,
Yes.
file a response, then next date, hear the matter. So it goes on and on.
Obliged.
Obliged.
Item number 3.
Yes.
Your Lordship, in this matter, respondent are supposed to file affidavit, and regarding respondent number 9, service has been affected. I'm bring that I may be allowed to file service affidavit.
Lordship, I'm appearing for respondent 1 and 2.
1 and 2. Quite a number of respondents are here. Who's appearing for the other respondents?
Lordship, I'm appearing for respondents number 3, 4, 5 and 6, Lordship, and 7.
Okay.
For KHADC, respondent number 8.
8. Have you filed your counter?
Lordship, not yet, Lordship. Making a similar prayer, Lordship. Lordship, in this matter, Lordship, we'll be relying on the affidavit filed by Union in item number 1.
Anyway, that is up to you. Then the counsel for the petitioner has submitted that the notice issued on respondent number 9 has been affected, and prayer is made for filing of the affidavit of service. Pray aloud. All the respective respondents have.
Lordship, respondent number 8 is not filing affidavit.
Okay. Then respond. You 1 and 2 you will be filing.
Lordship will be relying on the affidavit which is filed by union in item number 1, Lordship.
Is it connected?
Yes, Lordship.
It's not tagged together, my lord.
Not tagged together.
No, Lordship.
That would be very cumbersome. You file. You may file a similar or identical affidavit, but do it separately. Otherwise, it becomes difficult later on.
Lordship.
Then a counsel for the respondent number 1 and 2 has submitted that the counter affidavit may be allowed to be filed within the next date fix. Similarly, Ms. N.G. Shla, Senior GA, appearing for the state respondent 327, has also submitted that the counter affidavit may be allowed to be filed within the next date fix. As prayed for, this is matter to respondent number 8 has, however, submitted through its counsel that no affidavit will be filed as far as the said respondent is concerned. On pre-meet, this is matter to 2 weeks.
Item number 4.
My lord had called for the CD, and in the meantime we have implemented the complainant, and also we have served a copy to the complainant, dusty service to the complainant.
Your Lordship, I'm appearing enter appearance on behalf of the respondent number 3.
The complainant.
The complainant.
Okay.
You have filed your power? Have you filed your power?
We'll be filing objection with regards to the.
Then we'll hear your objection today. But you have not filed your power.
Required to file by way of affidavit. You can just hear it.
No, not necessary.
Not necessary, my lord. And in fact, I was just going through the other day the judgment, my lord, with senior. That's the complainant needs to be made a party only in those sexual offences, those cases, not in this complaint.
No, this is what.
This is
Not
315. Right? 315.
Yes, then
no, it's not required actually, my lord. But sorry, I could not that day assist my lord properly.
Required. Only in those matters like
yes, it's an IO,
POXO
matters and some three. Yes, my lord, all these matters. My lord, before my lord takes up the merit and sees the court, with the permission of the court, I would like to show some WhatsApp messages, my lord, where I, as a officer of the court, have been attacked by the complainant, and this is I like to give a copy to the prosecution also, my lord, because I am only doing my duty as an advocate and an officer of the court, depending, and this has been posted in her status where many can view. So
then you take necessary steps.
My lord, just wanted to bring, my lord, what kind of because
what can we do,
my lord? So, my lord, I was my lord, as I was submitting the other day, my lord, I seek protection of my courts, of my lords, from being arrested because the FIR, my lord, the FIR that has been filed and the charges that has been leveled against me, my lord, I can be arrested because this is an offence which
you've been given interim protection.
I have been given the interim protection, my lord.
So we'll hear the complainant.
My lord, my lord.
And the matter will be disposed of.
My lord, exactly, my lord. Yes.
My lord, we're praying for 1 week time to, because my senior he's out of station, so he'll be.
Let the interim continue, my lord, and in that case.
Miss has submitted that she's entering appearance on behalf of the respondent number, the newly implemented respondent number 3 or 2.
3.
However, the power could not be filed today and will be allowed to be filed in due course. On preempt by the said respondent, this matter is to be heard on the next date fix. In the meantime, as prayed for by the learned counsel for the petitioner, the interim relief granted will continue till further orders.
My lord. Obliged.
This is matter two.
Case diary is before us.
Is that the case diary or the copy of the case diary?
Copy of it.
Then it's not necessary.
Obliged.
What you can do is next date when the matter is listed, you produce the latest status report.
Obliged.
This is matter for 1 week.
Item number 5.
May I please, Your Lordship, kindly allow us 2 weeks' time to file our rejoinder affidavit.
Lordship, I have already placed Lordship before also that if they are disputing with any such things like under section 14B or any of the orders, then they have to go for appeal. This is not the forum to
Section 75.
section 14B of the
Appeal provision.
7I, section 7I.
Provision appeal is how? What is the provision for appeal?
Provision for appeal is if order is passed under section 7A, 14B, 7Q, all this thing, all the orders which are passed under these sections, then under 7I they have to go for appeal. So, Your Lordship, this matter is getting lingered without getting into a proper forum. They are lingering here, whereas first they have to approach the appellate court, and I have already mentioned before also.
Anyway, that you see, once the matter is heard in its entirety, then if that direction is required to be issued, then it will be. Because what happened is now the process is on.
Lordship,
We are waiting for the. You have filed your.
I have filed my
counter.
I have filed
You have to
my
file the rejoinder.
rejoinder, and also Lordship, they have not since the account is freezed, they are also not paying their dues. It is getting hampered also.
No, but it has been unfreezed, isn't it?
No, Lordship, because it is the account is not yet unfreezed. Sorry, it is unfreezed. Sorry, Lordship, it is unfreezed. Yes,
Exactly.
it is unfreezed.
If I
Yes, the
God.
account is unfreezed, so they are not paying also. So that is
if you see like I said, at the end of the day, if they are found to be wanting, then necessary direction will be given, penalty provision will be applied, all those things will be there. It is not as if it is not as if everything is lost.
Lordship.
Whatever is to be recovered, whatever is to be imposed will be there,
Lordship.
including penalty if it is up to the discretion of the authorities concerned or the court for that matter, then they will be penalized.
Lordship.
But since the matter is at this stage where we have to wait for the reply, so we'll have to do that. How long is it?
2 weeks' time, Your Lordship.
But be sure
Yes.
produce it within 2 weeks, otherwise we'll hear the matter. These are these are matters which are which involve social welfare legislation. Court cannot just sit on it. Neither the parties should sit on it. The counsel for the petitioner submitted that the rejoinder to the counter affidavit filed by the respondent 123 could not be filed today and has sought for accommodation as far as the same is concerned. On preempt, the same is allowed. However, it is made clear that the said rejoinder should be filed within the next date fixed, failing which necessary order shall be passed. This is matter after 2 weeks.
Mr. President. Hearing correspondent number 4, Lordship. Multiply, Lordship.
Item number 6.
Lordship, this is a matter regarding the ex gratia payment where we were supposed to give a bullet point submissions as well as verbal.
Matter has been heard.
Not yet heard in full. It is in part it has been heard, but now it appears that my colleague from the other side is on sanction leave.
2018 matter.
Yes, Lordship. It's their case, they are delaying it.
On pre-made on behalf of the Leonard Senior Counsel for the petitioner who is said to be indisposed, who is said to be on sanction leave. The same not being objected to by the respondent. This matter is adjourned. This is same after 1 week.
Item number 7. If this matter can be taken up on Monday, my lord. Mr. Paul is not here today, my lord, due to some personal difficulties. Praying if can be listed on Monday, my lord.
What is required?
It's for final hearing, my lord.
Final hearing?
My lord. I'm again appearing on behalf of Mr. Sengupta.
On pre-made by the parties. This is matter to 1 week.
Item number 9.
Lordship.
Yes.
This matter I have a limited prayer. Lordship had heard this matter once.
Now I've
My
forgotten.
limited prayer is that, Your Lordship, which my learned friend also has conceded to that.
Okay.
There was a suit that was filed against me before the District Council Court. Injunction was granted. We were heard, then the injunction was made absolute. Against that, we filed an appeal before the judge, District Council Court. So the judge, District Council Court, recused himself from the matter because he somehow has some connections. So he had endorsed the matter to the additional judge. So the matter was taken up by the additional judge. It was heard, it was fixed for judgment for 4 long years. We've been inquiring on every date. So what happened suddenly, without our knowledge, this case was filed before the judge, who had recused himself from the matter. He took up the matter, issued notices, and those notices was not received by us, nor my relatives. Dispose of the matter and dismiss my appeal. So I am before your lordship only to a limited prayer to set aside the order and remand back the matter to the original judge who was seized of the matter and hear the matter again. That is my prayer.
Yeah, I have no objection. But Mr. Learned Counsel for the petitioner, who has submitted that this application has been filed under Rule 6 of the High Court of Meghalaya, under bracket, jurisdiction over district council courts, close bracket, order 2014, read with Article 227 of the Constitution of India. Next, the Land Council has submitted that the petitioner herein had instituted. You have instituted it?
No, they have.
We have. That's what the petitioner herein is
instituted a title suit number 24 of 2013.
So the respondent has done that?
The respondent
has submitted that the respondent herein has instituted a title suit being number 24 of 2013.
Along with an injunction, in this case. In this case 24.
Along with an application for injunction before the court of the
Presiding officer, district council.
Presiding officer, subordinate district council court.
Your lordship.
The matter was, the suit was decreed in.
Not decreed, only injunction.
Injunction was granted. Only an
injunction was granted.
This case was.
Injunction was.
As far as the injunction is application for injunction is concerned, the trial court has passed an order in the nature of
10/7/2020.
Dated 10/7/2020.
Whereby injunction will be made absolute.
Whereby the said injunction was made absolute, being aggrieved by the said order dated 10/7/2020, the petitioner herein had approached the appellate court, that is the judge, district council court, assailing the said order, assailing the said impugned injunction order. In the meantime, the learned judge had recused himself from the matter, and the appeal was then taken on board by the additional judge, district council court, who has heard the parties and had reserved the judgment. In course of before the judgment was finally pronounced, and the respondent herein, it was a respondent, not finally, respondent herein had then filed a misapplication
before the court of the learned judge, say council court, and on the prayer so made, the learned judge, the say council court, had again taken upon himself to hear the said appeal. That is, by withdrawing the said appeal from the court of the additional judge, the council court. Stop. Next, it is the submission of the learned counsel for the petitioner that the petitioner was not informed of such development, as no notice has been issued upon.
We had not received notices.
As no notice has been received by him. In the meantime, the matter was heard by the learned judge, the council court, and an order was passed.
Page 520, it seems notice was issued, but they say they have not received. That is a different matter. But notice was issued from the court. Page 520.
Okay, they have not received.
But we have not received.
Is there any indication that they have received?
No, it's not there. But notice is there. Page 520.
Notice is there. So what happened after that?
Because we have not received notice, the judge pronounced allowed the appeal.
And the order allowing the appeal was passed.
Not allowing the appeal, dismissed my appeal.
Oh, you are the appellant.
Yes,
you are the
appellant.
And the learned judge had dismissed the appeal. Next, being aggrieved by the said appeal order, the petitioner is before this court. It may not be necessary to go into the merits of this case, since on the face of it, apparently there has been a miscarriage of justice, inasmuch as the learned judge, by passing the impugned order, had traversed his jurisdiction when the matter was firstly recused by him, and again when the matter was seasoned by a competent court of by another court of competent jurisdiction. The same being on the verge of disposal. Be that as it may, since there is a breach of jurisdiction, an irregular and illegal order has been passed, which requires to be set right by this court under the relevant provisions of law. It is also to be noted that the learned counsel for the respondent herein has concurred with the submission made by the learned counsel for the petitioner, and has also agreed that the impugned order may be set aside and that the matter may be remanded
to the court of the additional judge, District Council Court, for fresh hearing.
Before the court of the additional judge, Shri E. Merton, because there are many additional judges.
Okay, additional judge, Mr. E. Accordingly, this petition is hereby disposed of by the impugned order being set aside and quashed. The matter is directed to be placed before the said additional judge, with the direction that the same may be heard afresh. Parties herein are directed to appear before the said court on
After 1 month, my lord.
Why 1 month?
There's a far-flung village, Lord. It's in
Then 29th? No, that's Friday.
29.
Or you suggest a date.
Any day, 29 also will do, just for appearance of the parties.
5th October, if one be, my lord.
On 5th October, for appearance of the parties. On 8th October.
And your lordship, status quo may be maintained again, because this court has already passed a status quo order.
Or has already passed.
There is already a status quo order from the original court.
In the meantime, the status quo order passed will be maintained
By parties.
by the parties until further orders by the court of competent jurisdiction.
Your lordship.
Shall dispose of.
Item number 10.
Yes.
Please, Lordship. Here, the petitioner is coming against the order of removal from the service, Lordship. What happened, Lordship?
Who's appearing for the parties?
For the state.
And for the state, my lord.
Managing committee. You have. Huh?
Opposition, we will rely on the affidavit filed with the state level.
Okay.
But before my friend begins, my lord, he may stand corrected. My lord, the order of dismissal is not under challenge in this.
No, Lordship, he is trying to mislead the court. I will satisfy everything. Why he is jumping from the beginning? No, Lordship. I will come to that. No, Lordship. I am the petitioner. I should be given an opportunity to address the court. Now he is jumping. Everything I will cover.
I am not jumping, my lord.
Come again, sir.
This is a matter of fact.
No. I will everything I will deal it.
Just tell me, what is your case?
My case is because he is jumping because they never supplied a copy.
Your case is because he is jumping.
No. Why he is trying to confuse the court? He is trying to confuse the court, Lordship.
I have not even heard the matter, so tell me.
That's why. He should be giving me a chance to say, then only let him raise. Thus he is coming to the conclusion part immediately. All these things, what learned friend is saying, I will cover it.
Let's do away with the rhetoric.
Lordship. That's why he should allow me to say, I am the petitioner. I should be given a first, so I can address the court.
Yes, please.
If anything, then he can reply. Now what happened, my lord? I was appointed this page annexure 1, page 15. This is the appointment order, Lordship.
Just a moment. Revne. Okay, so start from the beginning.
Lordship, I'm starting that I was the petitioner was appointed on 28 September 2015, Lord.
Appointed where?
Appointed in the as a teacher on the basis of the permanent salary, the school of Hirapara School, Lordship. Hirapara, that is the name of the school.
Where is your appointment?
Annexure 16 is the name of the school, is there, Lordship.
Your appointment order?
My appointment order, Annexure 1, Lordship, is type copy. Annexure 1, page 15. The original is at page 16.
So, this is your appointment order?
Lordship.
Petitioner appointed.
Since then, I have been continuing in my service, Lordship, from 2015 till 2019, that February 15, February 2019. Now, what happened, my Lord? On Annexure 2, my Lord, on February 15 February 2019, I was alleged that there is a letter where saying that I participate in the election, contested in the election, and thereafter they have just, without any so-called notice, without even taking disciplinary proceeding, without punishing all the document, no charges report, just issued this letter 15 February 2019, where they say that they have removed me from the school, Lordship. Where that letter says that MCS member Hirapara School had directed you to release you from the assistant teacher our school with effect from 15 February 2019, Lordship. That was so. They have released me. That means they have released me from school, alleging that I have contested in election.
Okay.
They said that due to contesting the 19 Dolan Rabah Hajong Autonomous District Council on 21st January, and accordingly to higher authority, we have concern that without resignation or without concern, with the authority have not right to contest any type of election. So on the basis of rules, so and so, we releasing you from our school. So this is the school. Then that's the end here. That original letter, this handwritten. Then your Lordship, what happened? May I take you to the Annexure 13 now, Lordship, Annexure 3. They said that the school education literacy, yes, issued the letter dated 27/03/2019, where it says that in close of February received the complaint President Hirapara School complaining that conduct of Florita, I am the Florita petitioner, assistant teacher, coordinator Hirapara, which is you are therefore requested to inquire into the matter and submit a detailed report to the office undersigned within a week. Now, my Lord, on the basis of this letter, your Lordship, may I take you to the Annexure 5, Lordship. Annexure 5, page 22.
So what is this Annexure 3 says?
Annexure 3 says this, actually this is the annexure where petitioner have admitted that he has said that he has received from the District Magistrate West Karo Hills, dated so and so, regarding the complaint, Hirapara. Okay. I really appreciate you to have this.
No, this is the request to inquire into the matter.
Lordship.
Okay.
Lordship, that is inquiry into matter.
So this is.
Then Lordship, page 22.
Yes. Page
22, Annexure 5.
Yes.
Now here, based on the complaint made by the secretary, the managing committee, the administrative and account officer, SSA West Karo Hills Tura, have issued a letter where is clearly mentioned. May I read later for your reference? On true pursuit of report so and so, dated 8/8/2019, submitted by the block mission coordinator, Trikila, it was observed that no proper permission or approval was sought for contesting the MDC election in Assam by Srimati Florita the moment, that is me, which is against the rule of the department. Thus, in view of the above, as desired by the committee for taking necessary action, this end, the undersigned for preventing such practice in future by any employee do hereby release Florita D. Moment from post of cluster coordinator of Hirapara CRC while allowing her to continue the service as assistant teacher of Hirapara school with strict warning to be more responsible henceforth. So, Lordship, what happened? Based on the complaint made by the school managing committee, I was holding the two posts. One is the cluster coordinator. Another, I am also teaching as a assistant teacher. Now, for contesting, for the complaining as a punishment, they have released me as from the cluster coordinator. That means punishment. So they have released. But however, Lordship, the administrative department have allowed the petitioner to continue in service. That was the day. Then after Lordship, and now I'll come to now page. I would like to come to the 28, page 28, the annexure 8, Lordship.
28.
Lordship.
Yes.
Now here, district mission coordinator again have issued another letter dated 20 December 2019.
Yes.
Where it says that, I will just read it with reference to so and so, was substitute departmentally released from her service from the post of coordinator based on your complaint and unauthorized contesting MJ without any knowledge and permission from authority since she was departmentally appointed for CRC. Regarding the termination release from assistant teacher, it is duty of the SMC since SSC norms, SMC are empowered for teachers appointment. The said teacher was appointed by the SMC, that is SMC of Hirapara School. DMC approved the appointment done by the SMC to all SS school. Therefore, you are directed to issue press order immediately to assistant teacher who is unwanted your school as your complaint letter dated so and so without sending any complaint to DMC. The DMC already done its part. The copy of the action taken submit to the office undersigned without fail. Now in this regard, what happened? Even this letter was under challenge. I'm challenging this order also. Right after issuing this letter, Lordship, there is no termination letter coming forth from the managing committee. The district mission coordinator have stated that it is the managing committee who have appointed. You have appointed. So if you don't want your teachers to be appointed, you take action or regarding the releasing or termination. That order was given and then submitted a report. This managing committee have never acted upon this order, Lordship. But but during the pendency of the case, Lordship, what happened? Now this is the whole case. Then there and then now petitioner, while as I said that they have released, the managing committee have released the petitioner from service, and then thereafter they again file a complaint. There was a punishment was given that I was released from the cluster coordinator. However, I was allowed to continue in service as a teacher. That means one punishment. And then secondly, they are not satisfied with the releasing of them, but they don't want my service. Then they file again complaint to the school authority. The school authority said that if you don't want, you have to take action against the teacher because it is you who have appointed the teacher. But this was never acted upon by this one. However, this or even this order we have challenged since on the ground that it become the double jeopardize. Number one, because Article 22 is very clear that for one for one action, two punishment cannot be given, because I have already released from cluster, from coordinate cluster, and still continue to allow to be in service. And secondly, my lord, now they allow me to as a cluster, as a assistant teachers, and there is a letter that if you don't want the teacher to be continue, you should take action. But that order, this 28 December 19, also was not acted upon. That means no action has been taken by the managing committee to the petitioner. That means this is the entire case. Well, they say that after that, the government have filed the affidavit in opposition. Now it comes to the affidavit in opposition. Well, they have clearly mentioned that, I may take the Annexure 6. Annexure 6, and their affidavit, lordship. Before that, Annexure 6. From Annexure Annexure 1, lordship. Annexure 1 and Annexure 2. May I come to that. The affidavit in opposition filed by the state respondent. State respondent.
Yes,
lordship. Annexure 1, lordship. The School Education Literacy District Mission Coordinator, dated 25. That is the Annexure 1, page 10 of the affidavit in opposition filed by the state respondent.
This is the order.
This is the order. Dated here, it is 25/6/2019.
25 or 5?
This is 25, lordship. 25. On top they have written 25. Down also they have written. Page 10 of the affidavit.
Annexure 1, isn't it?
Lordship. Lordship.
Yes, sir.
May I read, your lordship?
Yes, sir. This is the additional affidavit. Okay, just one. Yes, please.
Now, this is the order. May I read it also? I inform you that that the report submitted by SSA 25/19 with regards to inquiry into the complainant, CRC coordinator Hiraparai, by you. It is observed that you have not conducted the inquiry involving both parties, but has submitted only the reply submitted by the coordinator, making it difficult for the undersigned, and in understanding the matter, it is entity. You are therefore requested once again to inquire into the matter involving all the stakeholders and submit a detailed report to the office of the undersigned within a week's time, so as to enable the undersigned to initiate the necessary action from this end. This is they're saying that means there is no inquiry, they have admitted. And again, the School Education Official Literacy Director has again said that to conduct a press inquiry to the block mission coordinator. And now may I come to the basis on the pursuit of this one. They have stated that Annexure 11, Annexure 2, page 11, lordship.
Yes.
Lordship.
Yes.
This is the letter from T.S. Sangma, Block Coordination Administrator, Sikikila, so and so. Inquiry report on complaint against Hirapara Coordinator School regarding. With reference to subject stated, I have the honor to submit the inquiry report complaint against Florita Assistant Teacher Coordinator Hirapara UP School by SFC Committee SS School regarding the contesting 19 Dolan Rabah Hajong Autonomous Council as an independent candidate, which was held on 21st 19 without proper permission of SMC of the above mentioned school. The madam inquiry was conducted on 25 at the Hirapara SS school, but its school itself by undersigned along with the BRP Sri Nazari and SM Sangma, the coordinator Rajib during the time of inquiry, all the SMC were present. Madam, during an inquiry, as the teachers, the coordinators, the Florida gave her statement that she has contested the election as the Autonomous District Council as an independent candidate, which was held on 21st January 2019. She also told that she informed the headmaster through her father as she was unable to come and met teacher as well as SM teacher. It was also stated by the head teacher of the above mentioned school that her father took signature from the headmaster on the blank paper sheet and head teacher of Hirapara school, Sri Sengna Moman, given his signature with the seal on the blank sheet of the paper without knowledge of the other SMC. When inquired about the same, Simita Florida assistant coordinator SSC UP school, unable to produce, stating that it was misplaced somewhere at home. It was informed that SMC of the above mentioned school held meeting on February 2019. That meeting SMC member had decided to release Florita Moman, assistant teacher cum coordinator of Hirapara school, from her duty with effect from 15 February 2019 for her misconduct and duty. Now, this is very important, which I'm trying to read, Your Lordship. This is very important. That on inquiry about the procedure of releasing her from the post of assistant teacher, undersigned had observed that SMC did not serve so-called notice or explanation code before issuing the release order to Srimati Florita the moment. The undersigned also inquired about the final decision of the SMC member and observed that there was a mixed response. However, most of the SMC members decided not to take responsibility in their own hand. Instead, decided to hand over to district mission coordinator to make best decision in order to function the school smoothly. Now, Your Lordship, this is the very clear. This is my case where I'm trying to rely now. Earlier, I have secured that district coordinator has given the decision that if you don't want the teachers to be, because you have appointed your teacher, you take action, you terminate or whatever. They never acted upon it, they have not terminated. Now here it's very clearly stated that my case is that here they're saying that no so-called notice was issued. That means no proper procedure was followed prior to releasing the petitioner from her service. And they also, it is indicating that school managing committee who has appointed a petitioner, they don't want to take the responsible, either to throw away or either to remove the petitioner. They are saying that it is the state respondent to take action against the petitioner, not the SMC. What is the stand of the SMC? SMC, state government is saying that you take action. And the managing committee, on the other hand, saying that no, you take the best decision. It is you who should take action. So this taking action, they are blaming each other. Who should take action? What punishment the petitioner should be get? The letter is very clearly speaking. The letter also says that there is a clear violation of the procedure followed by what is provided in the Meghalaya Fundamental Rules and Subsidiary Rule, where it says that the section 9 is very, very clear, Your Lordship. Where I should rely the provision, the Meghalaya Service Disciplinary Appeal Rules 21, section 9. I think, my Lord, my habit. May I just read it? I have the copy. You have one more copy.
You should have given
Lord, this rule will not be
applicable. No. I'm just, let me complete my submission, then he can raise. I have still many more to say.
Okay, Mr. So before we proceed,
Lordship,
if you are relying on some decision or books, you should give an advance copy. Have you done that?
Yes, Lordship, that I have not done.
Should have done. Otherwise, now this court is caught unaware. The other side also are not.
Yes, Lordship.
But you are relying on some decision.
This is not a decision. This is a rule only. This is only book.
Are you proposing to rely on some decisions?
That this is I have those judgment. Actually, there is a recently order passed by the division bench. That copy I have. I can supply, but I did not prepare the.
You should give a list of that.
Lordship. Then I will prepare the list of book, and then also otherwise there is only one judgment passed by the division bench, where we have to set aside the notification issued by the government barring the teachers and the professors from contesting this. That is cover my case.
We'll look into it.
Lordship. After 1 week or 2 weeks, Lordship, I'll prepare this, whatever book I'm trying to reply, I will supply.
My lord, before that, my lord, in order to save time of this honorable court, my lord, if I'm allowed to refer to annexure 4 of our affidavit in opposition.
No, his time taking is no point, because he said he can argue. Otherwise,
my lord, only 2 small points.
Otherwise, Lordship is not going to pass an order.
Two
He's
small
only
points, my lord,
giving a time. So what is the point of argument?
Just a moment.
Two small issues.
I've heard you.
Yes, my lord. 2 small points, my lord, which I want to bring to the notice of this honorable court. One is, my lord, annexure 4, page 15 of the affidavit in opposition which we have filed, my lord. So, my lord, this is a letter which was issued on 25/1/2020, my lord.
Page?
My lord, page 15.
Page 15 of the affidavit in opposition, my lord.
Yes.
My lord, this is the termination letter. My lord will kindly see clearly the language. Termination letter issued on 25/1/2020. My lord, this is not under challenge in this instant writ petition.
That's what I'm saying.
Then my lord,
challenge, but they have never supplied this copy. It is only after filing of this affidavit.
Well, then the petitioner should have withdrawn.
No, there is another order from the other court where it says that this is the order dated 28 March 2023.
No, have you filed a rejoinder to
It
this?
is not under challenge, my lord. No.
Reason I think I filed it, Lordship.
My lord, then may I take my lord to annexure 6? Annexure 6, page 18. So that even the termination of the petitioner's service has been approved.
Okay. So
this is not a part of the.
Anyway, we'll hear him.
Lordship.
If
My continuation.
If he succeeds,
yes.
and if he fails, fails.
Lordship. And there is order also from the other court, 28 March 2020. They have never complained. They said that to submit all the inquiry report, detail this one. They have never produced till now.
That is not a fact, my lord.
No, it is in the record. How can he say this is the court order? Can he deny?
Don't shout, okay?
No, I'm just saying.
No.
He
you
said,
please address the court properly.
No, I'm not. I'm addressing the properly because he said it is not a fact. It is there on record.
Whatever you see, whatever issues you have, you raise it, but do it properly.
No, see.
Yes, my lord.
Do it properly. I'm doing properly. But
he's shouting since the time he started hearing, my lord.
No, it's not. I'm not shouting because it is a natural when. How can I? It is my nature. When I say straight or slowly, also it's like that. It is my nature. I'm not saying that I don't have any personal. He should not take it as a personal.
It is not a question of personal,
making submitting my case.
See, look. See, we are on live streaming.
Yes,
Lordship.
Everyone in the world is looking at you.
Exactly.
Lordship. Actually.
May I please, Your Lordship, just one line submission, Your Lordship. Your Lordship, affidavit of the petitioner, in the writ petition, one address is given. And in the cost title, another affidavit.
We'll look into that.
Yes.
Heard Mr. P.D. Sangwan and counsel for the petitioner. However, in course of hearing, the land council has said that he may be allowed to file a list of books and authorities that he wishes to rely upon. Prayers allowed that the same be filed with advance copy to the respondents. On premiere, this is matter for the hearing after 2 weeks.
Lordship. Much less, Lordship.
Item number 11.
Your Lordship.
Yes.
Yeah. This is a case BSF has acquired the land of the petitioner in near Dalu. They have released the fund also before the respondent number 2, the DC. And since they have not released, this is the case, Your Lordship. And they have filed affidavit in opposition, and we have filed on the 4th this rejoinder in response to that affidavit in opposition. I think Your Lordship may fix another date for hearing.
But in fact, there is another matter, my lord, which is pending before.
Another.
But that was
bench.
earlier round of, my lord. That is before court number 4, my lord. It's the same issue, because my lord, there is a dispute actually with regard to the who's the owner of the land, my lord, which is before the district council. So that issue is also there. Nevertheless, my lord.
But
So how will
that is
that,
already decided by district council.
So how will that affect also?
My lord,
And
few
there-
similar matters are before
Similar
this
matters
honorable-
in coordinate bench
My lord.
might.
My lord, earlier, because they are the new councils, my lord. The earlier council had made a prayer before this honorable court that that matter requires disposal prior to taking up of this matter, my lord. But nevertheless, we'll see, my lord, how things go.
Your Lordship, the issue is same, because the issue of land has been decided by district council finally, and it has attained finality in 2018.
But if you say if it's a question of ascertaining
Yes.
who is the actual owner,
Author
then
is the
that becomes a
CM.
that becomes an issue of facts, or rather a dispute of facts.
Can be fixed for hearing, Your Lordship.
When is that the other case?
My
Like
lord, in fact, this
on
matter,
another on 14.
this matter was listed today, my lord, before court number 4. So it has been adjourned for 2 weeks, my lord.
this matter is listed today.
My lord,
this
similar
one?
matter, my lord.
No,
Different
that
case,
one
my
on
lord.
14,
today?
Your Lordship.
Yes, my lord.
Oh.
On 14.
Adjourned.
another man.
Adjourned, my lord. It was item number 5 today, my lord.
No, that is a separate thing, Your
So,
Lordship.
so we'll do one thing. We'll list this matter after 3 weeks then.
My lord.
And we'll see how things turn out.
My lord.
On premier by the parties, this is matter after 3 weeks.
Obliged, my lord.
Item number 12.
Press some more time, Lordship. This is a dismissal from service. I was a police constable. So I was absent for 58 days, unauthorized leave, and I have served for more than 24 years. So they have dismissed. So I am raising the issue of technicalities because that procedures are not followed. So I need some time.
How long?
2 weeks.
On premier by petitioner, this is matter after 2 weeks.
Item number 13.
Lordship, this is a teacher matter, Lordship, where the service of the teacher was terminated after being in service for more than 12 years, Lordship. And this petitioner is before this honorable court seeking regularization of her service, Lordship. So, Lordship, as of today, I'm not thoroughly prepared with the matter, Lordship. So, Lordship may kindly fix this matter next week.
Who is appearing for respondent 1 to 4?
Well, I'm for the state, right?
Lordship, I'm for respondent 5.
You were not there last.
1 to 4 state respondents, my lord. 5 and 6.
Lordship, I'm for respondent 5.
On premier by the petitioner, on the ground that the Leonard Council is not prepared to be heard today. Matters adjourned. This is after 2 weeks.
Highly obliged.
Item number 14.
Common.
Two appellants, Your Lordship.
Item number 16.
Please, Lordship. Lordship, I pray for some accommodation, Lordship, in this matter. Lordship, my senior was here, Lordship was ready to argue the matter, but since they're asking for accommodation, so 2 weeks' time, Lordship.
On pre-made by the parties, this is matter to 2 weeks.
Lordship, right. Highly appreciate.